Hello. Today I'm with the Honorable Judge Margaret Noe, and Judge Noe has been instrumental in bringing the Michigan Supreme Court oral arguments to Lenawee County this year. And I would like to share a little bit of insight about this particular case that will be argued here in Lenawee County. Judge Noe, thank you for being with us today.
It is my pleasure to be here and to spend this time talking about a significant event that will occur in Lenawee County on October 19th. The Michigan Supreme Court, which consists of one Chief Justice and 6 other justices, will appear here, and 2 attorneys will argue an actual real case.
It's interesting that, again, we have an opportunity to see something that really happens, that's real life in front of us. And tell us a little bit about why this might be a little different than what we might see on television.
You bet. I know that certain television shows like Law and Order and The Practice, and the television is full of Law and Order type shows. Everyone is excited about it. The very difference about this, however, is that this is not virtual reality. This is a real, true case. In Law and Order, you see the events, you see the drama unfold, and then you see the resolution. It all takes place, and the whole case gets wrapped up in that hour with commercials. I can assure you there'll be no commercials in this presentation, but we actually will see a case that started way back in the year 2000 for the defendant, Stephen King, or for the plaintiff here, Stephen King, who had an actual problem with a third offense, drunk driving, which in Michigan is a felony, and you will watch how that is affecting his life even now in 2010. And it's been a long process, having been heard by many courts and having been argued at least twice before.
Well, you want to take us through kind of the particulars of this case? How did it finally reach the Michigan Supreme Court?
Well, it actually starts with Stephen King being convicted in 2002 of a third offense drunk driving. In Michigan, that is a felony. And there are certain occupations or certain licenses in the state of Michigan that preclude you or stop you from getting a license to do certain occupations if you have a felony. One of them is an occupation of insurance sales. If you have a felony, you may not sell insurance. Probably that is rooted in the fact that there's a lot of financial trust matters that go into an insurance policy that although you purchase a product today doesn't become effective until you die or till you reach a certain age. And so you have to be somebody who is very trustworthy. And there is a presumption or a concern that somebody who is a felon may not possess those skills or have that level of honesty. So in 2000, he was convicted. In 2004, he applied for a license to sell insurance with the Michigan Office of Financial and Insurance Services. He disclosed, as he must, that he had a felony. It was missed, and they granted him a license to sell insurance. Then, in 2008, the Office of Financial and Insurance Service found they had made a mistake. Now, he'd been practicing insurance sales from 2004 through 2008 when he got notice that he could no longer sell insurance. Well, you can imagine the devastation after spending 4 years in preparation and establishing an insurance business. And so he filed in the trial court in Ingham County. He filed his papers as he's supposed to in the trial court, which is the circuit court. And he said, "How can you do this to me? It's a terrible mistake. I didn't do anything wrong, and now I'm paying a greater penalty." And the judge in that trial court said, "Gee whiz, that is kind of sad, and we feel bad for you, and I'm going to think of this as not been fair." And he used what we would call equitable powers, powers of fairness. Equity has to do with being fair. And he said, even though the law says you can't have a license to sell insurance, we feel bad about that, and we're going to let you have your license. Well, the Michigan Office of Financial and Insurance Services said, that's not right. There is a hard core law that says you can't do it. So they applied to the Court of Appeals, which is the process in Michigan and in most states. First, you go to the trial court. If you don't like that ruling, you can go to the Court of Appeals. The Court of Appeals said, you know, it's an awful hard consequence, and we feel bad for Mr. King. And so we're going to affirm, which means we're going to agree with the trial court, and we're going to let you have your license back. Once again, the Michigan Office of Financial and Insurance Services, there is a law that says you cannot do that. We're going to take it to the Michigan Supreme Court. Now, the Michigan Supreme Court is asked to hear over 2,000 cases every year. And they can't hear. There's just not enough time to hear all those cases. So they will try to hear the cases that will have the most impact on the most people. And so they chose this case as a case to actually answer the question whether Mr. King's license was properly granted in the first place. Remember, he had the felony drunk driving even when he applied. And because at that point a mistake was made, does that qualify him for an exception to the rule, which very clearly says if you have a felony, you may not have a license to sell insurance. And so the court will hear that case and they will make a decision as to whether or not equity or fairness ought to have anything to do with a hard, fast rule. And we don't know the answer to that, but we do know that Mr. King has followed all the proper procedures to get where he's going. And that the Department of Licensing, the state, followed all the right rules to get to the Supreme Court. And the Supreme Court chose this case for our students to see up close and personal, as they say.
Well, it certainly did not take just 1 hour for this entire case to develop. And certainly, again, we have some issues that are in conflict here. Everyone's doing things that they believe were incorrect with the law. And also, we also have this idea of fairness. And how does that apply to every individual? So it sounds like a really unique case for the Supreme Court.
Well, you know, there are two types of cases that we hear. We hear civil cases and we hear criminal cases. And this case started as a criminal case. Drunk driving is a criminal offense. Here we are 10 years later, dealing with it on a civil level, because some cases have both civil and criminal consequences. But I do think that a lesson for all of us to be learned is that our actions have long-term consequences and effect. I am sure that although Mr. King has done what he was supposed to do all along, he must have great regret for the actions that led him to the felony in the first place, which was at least 3 drunk drivings that we know of.
Thank you very much. As you watch this particular set of arguments play out, there may be some things that you might see in the courtroom that might be new to you. Judge Noy, are there some things that maybe the students might look for as they hear the various arguments that are unique to the Michigan Supreme Court?
You can be certain that the justices, all 7 of them, have done a lot of research and they are well prepared to hear these cases, that they have read the briefs. The attorneys who will be arguing the case, whose names I don't have right now, but they are not local attorneys, they're attorneys probably from the Ingham County who started with the case or have worked with attorneys that are specially trained to do appeals. And they will be prepared to present their argument in the most succinct, which means the most precise and detailed manner, and as fast as possible. There are no litigants. You know, when you sue somebody, you see the 2 people in the courtroom and they snarl at one another and they, you know, get upset with one another or whatever the case may be. On an appellate level, there are no litigants present. I mean, they may be sitting, watching, like the rest of the citizens in the state, but they do not present. It's all based on the record. So the Court of Appeals does not have any litigants, nor does the Supreme Court. It's all done on the record. Transcripts. You see the people in the courtroom who are look like they're typing really fast. Well, they are typing very fast. They're transcribing everything that's said. All the justices have read that. The attorneys are really prepared. They'll each get an opportunity to spend about 15 minutes arguing before the Supreme Court. So this whole case could rest on what might look like 30 minutes, but it's actually hours and hours of preparation time for the justices as well as for the attorneys. Once the justices hear the case, and they will have lots of questions because they are prepared, and the attorney might want to tell them about what went on here, and the justice will say, "Excuse me, counselor, I would like to know more about this." And you watch how quickly that attorney switches that topic over because they're well prepared. They can move around the facts in their case very quickly, which is part of what our training is designed for. Then the justices will say, "Thank you, that's all." And then the justices will excuse themselves. They will go back and they will have some discussion, and this is what they do in every case. The fact that they're outside their Supreme Court chambers will not change their procedure. They will leave the bench, they engage in a discussion, and they agree and disagree quite regularly. And they will debate it as best they can, and then the Chief Justice will assign one of the judges to write an opinion. Then that opinion gets written and it gets passed around to all the justices, who most of the time will write they agree with this, or they will write what they call a dissenting opinion. I don't agree with this. And sometimes they'll insist that their dissent ought to be published. They're so confident of their decision that they want the people to know what they had to say too. Or so they'll either concur, which isn't like agree, or they'll dissent, and some do it silently and some don't. But then the majority will be the ruling. And that opinion, somebody will be drafting the majority opinion. As an attorney, we pay close attention to, was it 7-zip? Was it 4-3? We want to know 5-2. We just want to know how it came out, because the next case that looks like this, those attorneys will be quick to argue, well, they ruled this way, but it wasn't a full house. It was just a part ruling.
There are going to be implications in terms of this decision that will play out not only in the case of this gentleman, but also, again, in further rulings and also future laws.
That's correct. In fact, Mr. King tries to tell them there are only 30 such cases where felons have applied for this license. He tried to talk the Supreme Court out of hearing the case. Of course, it's bode well for him in both hearings, right? The trial court and the Court of Appeals. He said to the Supreme Court, "You shouldn't hear this case. It doesn't affect enough people." But I think that the Supreme Court thought that the fact that we were looking at a hard, fast rule and applying fairness principles was worthy of their attention.
Thank you so much for sharing this information about the case that we're going to see.
Thank you. I hope that our students benefit from it as much as I think they will.
We hope that you enjoyed this overview about the oral arguments that will be taking place on October 19th here in Lenawee County.